Hello, everyone, and welcome to today's webinar, Taking Care of Your Clients and Taking Care of Yourself. What do you need to know about the effects of the coronavirus on your duties to your clients and your organization? I'm Dan McDonald from Baxter Media, and today is Friday, March 13th. Now, just before we get into things, I'd like to let all the viewers know that if you have any questions during this webinar, just type them into the Q&A box, which is found in your Zoom toolbar, and those questions will be answered in due time. Speaking first today is Timothy Law, partner with Heifetz Crozer Law here in Toronto. Hi, Tim. Thanks for being here.
It's a pleasure to be with you, Dan. Doug and I are both very happy to be here, although happy might be the wrong word given the global pandemic we're now told exists. As some of you may know, we provide legal advice to the Canadian travel industry, and obviously this problem has been on everybody's mind and a big focus of our attention in the last couple of weeks. We are speaking today based on what we know today. We've been tracking things for the last few weeks, and we are going to be talking again with you next Wednesday at 1 p.m. in order to update everybody on a second webinar. For today's purposes, we want to take you through the legal issues that you are all facing, some of the practicalities of what's going on as far as commissions and changes in booking policies, and to give you some basic principles that will hopefully be of assistance as you try and help your clients and as you try and manage your businesses. So, without further ado, let's talk about some of the effects of the virus that we have seen past few weeks. Cancellation of travel services by suppliers, quite obvious, obviously. Events being cancelled, most recently in our part of the world, hockey games and basketball games and all sorts of other attractions all over the world, like Disney, we all learnt yesterday. The other effects are obviously people's ability to enter and depart from the places they live and the places that they've gone to for their travel. Quarantine of travels has been a big issue. Doug and I have been discussing that with our colleagues in Europe because that's where significant quarantine issues were being dealt with, and that's something we'll talk a little bit more about as the webinar carries on. Obviously, you are inundated, as are all of the people in the industry, whether they are airlines or cruise ships or insurance companies and travel agents, probably in the most difficult situation, with requests. How can you help me? How can I get my money back? How do I know whether I should travel or not? And we want to address that sort of advice that you're going to be giving to them. There are going to be claims by customers for refunds and credits, another obvious one, and something that we've been tracking as far as what individual suppliers have been offering by way of refund, by way of credit. And the last issue that we will talk about is managing employees and the workplace and how you're looking after everything on home ground and the obligations that you have as owners and operators of travel companies to your most important asset, the people that work with you.
And this is Doug Crozer saying thank you for tuning in. We're trying today to advise both suppliers on one hand and travel counselors, travel advisors on the other. This current slide deals with the suppliers. You'll find that during the course of the hour, Tim and I will be frequently referring to the need to rely upon existing contractual terms. To a large degree, you can't just make up a response to an emergency situation like this on the fly. We're going to be referring you back to existing contractual terms. To a large degree, the horse has left the barn on this pandemic. You're left with the terms and conditions that you've got, with one exception I'll get to in a second. But you may want to diarize that once things settle down from this, if you're a supplier, you may want to go back and look at your terms and conditions and see what you've learned from the current problem that might inform changes to your terms and conditions for the next time around. you can change the terms and conditions now in midstream, but only on a going forward basis. You can't change the contractual terms for somebody that is already booked with you, but you certainly can change going forward, and that first bullet indicates that you must be disseminating the details of those changes immediately, and you're going to want to be able to prove that you've drawn these changes to the attention of people going forward. That need to harvest and to maintain proof will be relevant if you've got 2 or even 3 or 4 different sets of terms and conditions as this thing evolves. If you are changing during the course of it, you're going to have to be able to prove which set of terms and conditions applied to which passenger. The force majeure term is one that's going to be the subject of a separate slide that Tim will deal with in a moment, so I won't spend any time on it. The denial of boarding to those who have had contact with anyone with the virus in the last 14 days is problematic. It depends upon the honesty of the passenger giving an honest answer to that question. And again, depending on the terms of your contract, it may get you, the supplier, into more difficulty with the passenger than a mere refund of the money, if that is your policy. If you're denying somebody boarding and saying, here's your money back, in theory, if the passenger is going to a destination for a specific purpose, and that purpose is denied him because you've denied boarding, the damages that he could claim go beyond the mere refund. So it's a dicey situation if you are going to deny boarding. You certainly can only do it if your terms allow you, and even in that situation, you're going to want to look to see what your terms say, and you may want to consider getting legal advice on this on the case-specific example that you're dealing with. We're seeing on the news the cleaning of equipment after use is widely being done, to our understanding. I don't know how close to 100% any supplier can get, but certainly it's an obligation that should be fulfilled to the nth degree, to the extent you possibly can. The bottom bullet on that page and then the next page involve a variety of suggested policy responses that suppliers could have in terms of refunding deposits, converting deposits into credit for future travel at the bottom. And then Tim, if you could flip it over to the next screen, there's a variety of other options that are offered there. I'd mentioned a moment ago that force majeure was something Tim's going to talk about. Just before he does, I'm going to transition to his next slide by referring to the concept of a frustrated contract. In the stuff that you in the industry are seeing, there's the occasional reference to frustrated contracts as distinct from force majeure. We don't have a screen up for frustrated contracts, so I just wanted to take a moment on the transition over to Tim. Ontario has a very short statute on frustrated contracts. I assume that other provinces do as well. It is not overly helpful because, and I'm reading from it now, the application of the Act, it applies to any contract that's governed by Ontario law that has become impossible of performance or been otherwise frustrated. The statute doesn't define what constitutes a frustration, so one has to look at the case law that has developed over time to see what is frustrated, what the circumstances are that lead to a frustrated contract. In general, it goes to the root of the contract. The typical example given in law school is if I agree to sell to Tim a horse with the closing of the deal to take place on March the 31st, and if the horse dies between now and the end of the month, the contract is frustrated. The whole subject matter has been rendered impossible. Because of that, it leads to the termination of the contract, and because it leads to the termination of the contract, it tends to have a higher standard of proof than force majeure. Force majeure can lead to cancellation, but it can also lead to mere deferral or suspension. And with that bridge then to the next slide, Tim, it's over to you.
Thank you. So the majority of suppliers that you deal with, whether they are tour operators locally across Canada or internationally, or rather I should say, they are suppliers of specific services like air travel, hotel, etc., will have a clause. It may not be called a force majeure clause, but they're often referred to as act of God clauses. They are considered to excuse somebody, one of the people who's acting under the contract, from providing what they were supposed to provide. And as it says in the first bullet point, they deal with unexpected circumstances that are beyond the control of the supplier and that prevent it from providing the services sold. An example of some of the things that are typically in a force majeure clause: war, threats of war, riots, terrorist activity, industrial disputes, health risks, epidemics, weather conditions, sanctions, or other government action. These are all things that are outside the control of any of the suppliers you are dealing with at this time. And it's those clauses that the suppliers are going to have to rely on in order to say, we can't perform our part of the contract. We can't do what it is we said we would do for you. And as a result, we are not responsible. They have to be able to say, and this in this circumstance won't be terribly difficult, I don't think, that there is proof that this thing occurred, this event occurred, and maybe that it was unexpected. And I suspect that very few of us, if any, were sitting thinking 6 months ago when we booked our own travel plans, or we were booking on behalf of clients' travel plans, that there was going to be a pandemic virus as of March the 13th in 2020. And so I don't think anybody's going to have too much difficulty in demonstrating it was unexpected. The proof of its occurrence is in the media, is in the travel press, and is therefore equally unlikely to be a difficult thing to prove. As a result, we expect that lots of people will be relying on this particular clause that exists in their contracts. Let's talk some about advisors. I see there's a question that has dropped down there. Is that a question? In a force majeure, is the supplier required to refund now they can't provide the service? No, it's not that they are required to refund now, it's that the force majeure clause excuses them from providing the service. They're not obliged to provide the service. The terms and conditions, the other terms and conditions, will then determine to what extent something was refundable or not refundable. So moving on to advisors dealing with effects of the advisors. We are suggesting that all advisors tell their customers that they need to confirm with suppliers. I'm wondering, did I just jump down? My apologies, I may have just... Yes, okay, sorry. There's the clause, advisors dealing with effects of the virus. So first of all, and this is something that we tell people all the time, it is important that terms and conditions be brought to the attention of customers before any payment is taken, and that you have proof of that. Why? Because these terms and conditions of the suppliers, which include force majeure clauses, are something they want to rely on. They can only rely on them if, in fact, there has been a contract made that includes them. That only happens if they are brought to the attention before the customer pays. The other part of what we're suggesting everybody do in the capacity of advisor is not start interpreting the circumstances around the world, but telling your customers to look at local, Canadian, or wherever they happen to be, and the destination government websites to see what it is being said by those people. The World Health Organization is another place to look at, and the Center for Disease Control also has a website. They all have information that deals with circumstances in various parts of the world, and it's for your customers to decide based on what they're seeing whether or not they want to travel. This may be affected if services are simply cancelled, but to the extent that they are still on offer, this is a decision for the customer to make, not for you as advisor. We talked earlier on about updated supplier policies. We appreciate they are literally changing by the hour, if not the day. And you need to be aware of that. One of the recent changes was a change to a number of travel insurance policies, and that's something that you need to be aware of to the extent that you're selling travel services at this time. Similarly, when it comes to insurance, if somebody is being provided because of the virus, then you should be telling them to contact the insurance provider, whatever the company is. Those insurance providers are being inundated with calls, as you are as advisors today, so they may not be answering as quickly as you would like, but they are the people that should be speaking to the customers to advise them whether or not there is coverage for the problem they face. Same thing when it comes to suppliers. It isn't for you as advisor to be interpreting the terms and conditions of a supplier, but rather to be telling any of the customers that have a question, please contact the supplier. They will be able to tell you if in fact this particular term, this particular refund.
Tim, are you still on the line with us? We can't hear at the moment. Just want to make sure you're not muted. Tim, can you hear me okay? Apologies for the brief technical difficulty. Tim, we can't hear you right now. Oh, here we go.
My apologies. Can you hear me now?
Yes, we can. Loud and clear. Thanks, Tim.
I beg your pardon. Sorry about that. So when a representation is made, Mr. So-and-so, you are traveling on business class with this airline and staying in this particular hotel, you've made a representation. To the extent that that changes, customers need to know. Now, in circumstances like the virus, there's a good chance that they do know, but again, this is an opportunity to refer these people, the customers, to any of the websites that we talked about so that they can get as most up-to-date information as possible that they can use to decide whether or not they want to use the travel services that are still available to them. Providing advice within areas of expertise. This is very important. We all have our areas of expertise. Yours is in the buying and selling for your clients of travel services. Neither your expertise nor my expertise is telling any of clients whether the virus is going to get to the particular corner of the world they're traveling to. And so we are not, either travel advisors or lawyers, qualified to start telling people about where this virus will be and when. And you most definitely want to avoid getting into discussions when a client says to you, well, do you think it's going to get to the southernmost tip of Jamaica? We've heard there's a case. That's not a conversation you want to be having. That's something they need to decide for themselves. Same thing in the next point. And the penultimate point on that page talks about the effects of the virus. Same idea. We aren't qualified as lawyers or travel advisors to start telling people what the effects might be if they go and they don't come into contact with someone, or if they go and there is a problem. You do not want to be getting into discussions with your customers as to whether or not the virus exists in a particular part of the country they're going to, or how it may or may not affect them. Not an area of expertise. The last point, whether the person books or not, in other words, you're having this conversation with them, regardless of whether they book any travel services with you, you do not want to be having this kind of conversation or this subject matter conversation with, because you simply want them to suggest at some later date that you told them it would be okay to go because you told them the virus wasn't really going to affect them that much.
With the hope that by repetition, one of our core messages will come clearly across. Let me repeat the point that Tim has just made using another example of the same point. You guys are professionals in the travel industry. You know your job, and you roll your eyes when someone like me, who is not a travel professional, tries to book my own travel. You wonder why I'm so stupid as to venture into an area that I know nothing about. What we're saying to you is you're not medical experts, so why would you venture into that area? You're not experts in interpreting insurance contracts, so why would you venture into that area? The parallel exists, and again, hopefully by repeating it with an example, that message comes through loud and clear. On the screen in front of you, we can illustrate just how fast this is evolving. The screen has an outdated quote from 4 days ago on Monday, and indeed in that first point there's a talk about an update on what Dr. Tam had said on Monday, and it's gone beyond that now. We didn't have the website when we put this PowerPoint together, but there are a pair of government websites, the specifics of which I'd like to slowly give to you now over the voice part of this broadcast. There are two of them. They both have the same core root, and then there's a slight divergence. Of a general nature, it's www.canada.ca/en for English /services/diseases/2019-novel NOVEL -coronavirus-infection. At that point, they diverge. The general website ends with .html. The travel-specific one has an oblique slash after the word infection, followed by latest-travel-health-advice.html. Chances are you can get that just by Googling coronavirus, Government of Canada, health warning, something like that. But those are websites of the sort that Tim had referred to in the previous slide that you should be directing passengers to rather than giving your own opinions. The last bullet on the point on the screen is the specific point that Tim had said not to insert your own opinion in, rather just be a guider of your passengers to the resources, be they medical information or insurance information or supplier information that that will allow the passenger then to make up his or her own mind. We now move to insurance, which is the next slide, Tim.
Yes. So this has been an interesting journey in the last few days, as I said, and we've put in the slide there, Manulife to go, and I believe it was yesterday or the day before that Alliance followed them, saying that you will see in any given policy that there are known events, and we won't cover you if you decide to cancel or interrupt your trip because of a known event. What Manulife has done is said from now on, from March the 5th forwards, the existence of the virus will be considered a known event, such that if you're buying a policy after March the 5th, you are not able to rely on that policy to get reimbursed if you choose to cancel or to interrupt your trip. All of you need to be aware of. It's perhaps not surprising to you because, excuse me, it is a world event and people should know it, but you need to be aware to the extent that you are encouraging people to purchase a particular insurance policy, and I realize everybody has their favorites. Be aware of any changes of those terms, because you're not, in that case, getting into an interpretation of the policy, but rather simply saying, here's what Manulife has said. This Manulife policy is no longer going to cover these circumstances. What I say at the bottom relates to trip interruption coverage, if that in fact is in the policy. And I know that up until now, we've said to you, do not interpret the insurance policies. And I'm going to say that again now, and I'm going to say it again afterwards. But we did want to explain that some people seem to be under the misapprehension when it comes to insurance policies, that if there is trip interruption and somebody goes to wherever it is they're going, the trip needs to be interrupted because of the virus, and they end up staying as a result of being quarantined, then the trip interruption insurance will provide that person with the parts of their travel that they didn't receive. So if they were going on some form of tour, had they, for example, gone to Italy, and they were then embarking on a tour of all of Italy, bus tour or whatever, if the interruption occurred, then they would be entitled to claim from the insurance company the services they didn't receive. But some people seem to be under the misapprehension that they would also be covered for the costs of the staying for this additional time in the location. And it is very unlikely that that is something that's going to be covered by these types of policies. You will be able to get home, you will be able to buy another flight, but people should not be expecting that they are going to be able to live in a particular hotel or receive certain services and cover it or have it covered by the insurance policy. This brings us back to the quarantine issue that we raised at the outset. There have been quarantines put in place, especially over in Europe, and that is an issue that as yet we have not seen resolved. Who is going to pay when a government decides to quarantine 50 or 100 or 500 foreign nationals and keep them in their country? And we don't have an answer for that right now. We don't know what position the governments are going to take, but that is certainly an issue for all of your passengers moving forwards.
There's a question that has come in about those URLs that I had just given a moment ago. Let me refer it on to you, Dan. How can I most easily provide those URLs to the listers?
That's right. So you can, if you find the chat box in the Zoom toolbar, you can type it into there. Another option is when I email everybody the recording link to this webinar at the end of the day today, I can also include the links in that webinar so that everything's in one place.
That would be better from my point of view, because I can't walk and chew gum at the same time. And if I'm talking and typing, something's going to slip.
So I will happily send those resources to everyone in the same email that the recording is in.
Good. And after we sign off on this one, I'll send them to you, Dan, so that you can do so.
That sounds great. Okay. Thank you very much.
We're now on to the slide that's on your screen about managing the office environment. The bullets on the screen and the next page, are largely practical in nature, and they will be things that probably come naturally to you without being reminded of them, or things that you've read in the consumer press and in the travel press as to things that you can be doing. They're not wrong, but they're pretty basic. Do take note of them, especially the 2, 4, 6th one, the idea of reducing business travel would seem to be counterintuitive, because many of you are in the business of making money because other people travel for business. But the short-term loss to you of reducing your own business travel, we think would be more than made up for by the benefit of reducing the impact and, to use the phrase that the talking heads on TV are using, flattening the curve. The idea of having the impact of the virus spread over a longer period of time without a bulge is a good thing, because health resources are going to be strapped to the extent that they may break if we all come down with it at the same time. Therefore, deferring business travel is a good idea. From the legal side of things, we're talking about things like a policy within your office for dealing with COVID-19. If your office is large enough, you may want to establish a specialized committee that would support your staff by monitoring developments, being the focal point for updated information from outside or from within your organization as to internal health and safety policies, and their communication to your staff. Things that could go into a policy like that are things like an obligation on the part of a staff member to notify their superior if they or someone that they're in close contact with has recently traveled to or returned from an infected area. The policy could impose a minimum 2-week hiatus, time away from the office, for those that have come from those areas or been in direct contact with people who have. And the policy could impose an immediate obligation to seek medical treatment regarding self-isolation and quarantine and other measures that could be drawn upon in the face of the virus. The policy could also go into things like the employer's duty to the employees. You've got to balance, on the one hand, safety, and on the other hand, things like workplace harassment, violation of privacy rights, and human rights considerations. The general press is talking about perhaps an increase in ethnic-based comments about COVID-19 that would violate Ontario and other provinces' human rights legislation. You've got to be careful about that, and your policy could deal with those sort of situations. Likewise, on the harassment side of things. On the privacy side of things, consider whether you want to post, for example, on an employee's voice message, giving the reason why that employee is away. It's one thing for the message to say Mary McGillicuddy is away until Friday the 19th. It's quite another thing to say is away because she's come down with COVID-19. You can't do that latter without the consent of Mary McGillicuddy, and therefore you got to be careful about crossing the line in terms of human rights violations. Employers have a positive obligation to protect the health and safety of others in the workplace. So if you're faced with a scenario where someone has returned to work after traveling to an infected area or exhibiting symptoms of COVID-19 or was in direct contact with someone who fits that criteria, an employer then has a positive duty to protect the rest of the workforce from contracting that. That allows the employer to then step in and prevent the potentially infected person from returning to work for that 2-week incubation period that seems to become the normal, unless they have some letter from their physician that indicates they're not going to pose a threat to your workplace. Your policy could also take a look at restricting, indeed eliminating, visits to your workplace from clients and other guests. The buzzer on the door may be something that has to be activated in order that contact be made between somebody on the inside and somebody on the outside. In terms of an employee's refusal to work, the Ontario Health and Safety Act, and I'm assuming other provinces have similar legislation, gives to the employee a right to refuse to work if their work environment endangers their health and safety. So what I'm going to say next under the Ontario Health and Safety Act is subject to any collective bargaining agreement that might exist. But under the general regime, an employee has to promptly report to their superior their refusal and the reasons why they're refusing to work for this health and safety reason. That allows then for an investigation by the employer. That investigation has to take place quickly, and from a practical point of view, it should take place as close as possible to the workplace without imposing on the employee the obligation to come to the workplace to have that investigation. If the investigation and the dialogue that follows leads to a resolution, that's wonderful. If not, then a provincial labor inspector has to be contacted, and he or she then comes in and makes an investigation and gives a ruling. I would imagine that the time for a provincial inspector to come in and do that is going to be long. Certainly there's going to be a lot of similar situations. Their resources are going to be strapped. So that may well not be a practical route to take, just from a practical point of view, even though in theory it's there. You may well, as an employer or an employee, be left to your own devices to try to come up with some sort of a resolution of the situation of the refusal to work. And then speaking to employers, any employee who exercises their entitlement to refuse to work can't be disciplined or threatened or dismissed by reason of that. So then you get into the touchy question of payment. Again, this is subject to any collective bargaining agreement that may exist. It's also subject to any contract that may exist between the individual employee and the employer. That being said, from a general point of view, the Employment Standards Act says that if an employee has worked for at least 2 consecutive weeks, he or she is entitled to 3 unpaid leave days for each calendar year for personal illness, injury, or medical emergency. There's also provision for leave in the event of an illness of a family member, and that's a defined term. I won't necessarily get into it, but it's the scope of what is a family member is defined. Any employee that wants to take leave to care for a family member has to advise the employer beforehand, or if it arises in an emergent situation, has to let the employer know as soon as possible thereafter, and provide reasonable evidence. Those of you that are governed by the Canada Labour Code as opposed to the Ontario regime, there's similar entitlements for leaves of absence there. If there's a declared emergency, if the Canadian government has declared COVID as an emergency, then an employee is entitled to leave. That hasn't yet happened. The term emergency is defined. We haven't reached that yet, and hopefully we won't. But if that day does come, then an employee is entitled to step away. Subject to contract, let's make a distinction between employees who are unable to work and those who are symptom-free but prevented from work, for example, because an employer has told them to stay away. If an employee is unable to work, they're not able to collect salary or wages during the period of the absence, but they may be able to look to paid vacation time, EI, a workplace safety insurance claim, or a short-term disability claim if such a policy exists. For employees that are symptom-free but prevented from working are also not entitled to be compensated, but an employer that refuses to pay a symptom-free employee runs the risk of being sued for constructive dismissal. So it would be a situation in which careful legal advice should be obtained before an employer chooses not to pay somebody he's told to stay away from work. So the bottom line of the legal side of things, quite apart from the practical things on the screens in front of you, are that employers have got to consider safety first, and employees should know what their rights are and be in a position to exercise them if they feel compelled to do so. Back over to you then, Tim.
Thank you. I'm just checking this last question so that hopefully we can answer that. Who must pay for lodging and return flight in case of a group travelers has to stay in quarantine? Tour operator or clients are worried about that. It's going, unfortunately or unfortunately, going to come back to the terms and conditions. Just make sure I'm reading that properly. It's the same if it's a group or if it's an individual. If the quarantine is put on, the chances are that you're going to be telling your clients to deal with their insurance company in order to be able to get a flight to come back. If they don't have travel insurance that will cover this, then do what we said earlier on about governments deciding what they are or are not going to do as far as compensating people, including getting them back to where they belong once they've been quarantined, then that person, that traveler, is going to be obliged to find their own way back. Someone says they can't hear anything, Dan.
Yeah, the
I'll
audio's
leave
coming
Dan
through
to deal with the can't hear anything one, and just by way of PS to what Tim had said, the European legislation provides for an obligation on the supplier to provide 3 days worth of accommodation in a situation like the question poses. If your passenger can somehow find his or her way under the European regime, then that 3 days would be on the obligation of the supplier.
Fair enough. So let's talk briefly. We have a few minutes left. These issues are likely going to change, not the law part, but what's happening is likely going to change in the next few days again. Being Canadian and very civilized, of course, we only have an obligation to report our symptoms, not necessarily to stay away. But there are some laws, the Immigration and Refugee Act, the Quarantine Act, and the ability to effectively stop or manage people from coming in. As a Canadian citizen, you have a right to come into the country, but under the Immigration and Refugee Act, non-citizens can be prevented from coming into the country if they are a danger to the public health. We are not yet aware of the government having enacted any particular provisions under this, but it is a possibility. The Quarantine Act, and that's for everybody, that's not just non-Canadians, that's citizens and all others who is coming into Canada or leaving Canada. They are supposed to disclose any communicable disease that they or anyone with them has. Once again, the obligation is to disclose. And as Doug said earlier on, it's going to be difficult to enforce things like this if one is simply obliged to say, yes, I've got a problem, or no, I haven't. The Ministry of Health has officers. We have no idea how many at this point in time, but presumably that number is ramping up as well, that can isolate people if they are concerned about them or if they appear to be having problems. And we understand at the moment that a number of airlines are now asking a lot more detailed questions, certainly for people departing Canada, about their health. And I understand they have people with knowledge, medical knowledge, who are available to them in order to check those people out before we'll let them on the planes. The Quarantine Act also gives the federal cabinet the power to make orders banning or imposing conditions on travel if you've been somewhere else. And obviously, there's people moving all over the place every day of the week. We have yet to see these items being implemented as far as people who've arrived from somewhere and are heading off somewhere else, or are arriving from another country, specific ones that we've all been familiar with. We have not seen that. Viruses can also be dealt with under the Aeronautics Act and the conventions. They apply with air travel, and you won't be surprised to know that pilots are obliged, because in effect they are responsible for the safety, not only from being able to stay in the air, but also the health and well-being of the people that they have with them on their planes, and they have the ability to simply refuse somebody coming onto a plane based on concerns regarding their health. The airlines, the last point there on that slide, are supposed to report any illnesses that occur on board when they get here to one of these quarantine officers so that it can be dealt with. I don't know of any circumstance in the past when these people have been engaged in any massive fashion, but the assumption now is that they are going to be, certainly in the coming days and weeks.
Tim, while you were covering border crossings and quarantine, a question came in, and subject to what you have to say as a litigator, let me try and answer it. The question is, what liabilities do we, as an inbound travel agency, if our clients contract corona while on one of our trips in Canada? My answer would be none unless you knowingly expose them to a source of the virus. So, if you have produced or conducted the tour according to contract that they have entered into, you should be okay unless it turns out that such and such a restaurant or such and such a hotel has an outbreak. At that point, I would say you have an obligation to try to avoid exposing them to that. But aside from that, I would say none. Tim, tell me if I'm wrong.
No, that's agreed. Your knowledge of the circumstances will be important. Obviously, if you have any information that you are aware that you're bringing someone into circumstances where the virus exists, you'll have a problem. The difficulty today is, what is your knowledge, and what would you base your knowledge on? At this point in time, I think it's safe to say that we know there are cases of the virus in Canada. We know they're in Toronto for sure. And to the extent that there is a risk that you are taking people to where the virus is, it will always be a possibility that you could be found liable for whatever harm that person suffers. It'll just be a question of how do you prove what you knew.
Yeah, valid point. The final slide was designed to be a bit of a catch-all for things that we hadn't touched on earlier. Let me take a shot at a couple of things that are on the screen and then a couple of things that are not, and then invite Tim to fill in on other things that have come to his attention since we put this deck together, because the situation is certainly evolving. The claim on the business interruption insurance, we of course don't know whether a claim can be made or not, because it's going to depend on the policy wording. We've put this in as a reminder to those of you that might have business interruption insurance and have forgotten that you have. This is a bit of a kick, a bit of a reminder that if your insurance policy already includes it, or ask your insurance agent whether you, without even realizing it perhaps, acquired protection for business interruption, the terms of the policy may come to your protection. Likewise, the disability insurance policy is going to dictate whether or not staff are entitled to be paid if they're off work, either because they're ill with the virus or because you're telling them to go home. It's just this second bullet is just a trigger to remind you to consider that as a possibility. The specific terms are going to depend upon what the policy says. I covered the WSIB claims when I talked earlier on about the unsafe workplace and the need for an inspector if you can't resolve it directly. We had talked about insurance earlier on, anticipating a question that might come about cancel for any reason coverage that is being referred to sometimes in media reports. Be aware that it's not a 100% protection. If you have a passenger who has bought the CFAR, cancel for any reason, protection, usually recovery is limited to 50 to 75% of the money paid. And tell your clients that have that type of policy as well, there are obligations to make timely claim on that policy that they should be aware of. So it's not, having CFAR coverage isn't something that allows you to sort of lean back in your chair, put your feet up on the desk and say, I'm covered. There are limitations and there are time obligations. Speaking of time, we're getting close to 5 minutes to the hour. Tim, over to you to pick up any other loose ends on that final slide, and to you, the listeners, if you have any other questions.
Okay, I was just checking the questions and I don't see any, and I do want to come back just to that insurance piece that I mentioned before, and I said we'd put it in the slide that policies are not necessarily going to cover exactly what they appear to. And then I want to back up and underline again that you do not, as a travel advisor, want to find yourself in a position where you are being asked to, or you are actually interpreting an insurance policy for your client. The expertise for that lies with the company. They have people that do that if people have questions. Over the years, in the last 25 plus years, we've had many cases where agents have interpreted what a pre-existing condition is. This is no less disastrous if you try and interpret whether or not this is going to cover this sort of problem, the virus. I thought I saw another question.
There is
yes.
one. I'll take the one on travel insurance from Richard D'Souza about whether the agent has to go through the whole policy word by word. The answer is no, but you can't just blithely ignore the specifics. I think you have an obligation to say, look, there are key points in here you should be aware of, bing, 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 bing. There are obligations on you, just as I mentioned earlier in the CFAR example. You have an obligation to make a timely claim on the policy. I think you can summarize in a fairly effective manner the key points while emphasizing the obligation is on the passenger to go through the detailed policy. And if they have any questions, they can be referred to the insurer for clarification. So it's perhaps a midway point, Richard, to your question. You can't do nothing and you don't have to do everything, but you have to hit the highlights and make it clear that you're not the expert on insurance, the insurance company is, and any questions should be referred to the insurer.
And I don't think we addressed the force majeure question, so let me do that as our, I guess, last answer. Did we say that the clause means the client may still have to pay cancellation? What I'm saying is that the force majeure clause may allow the supplier of the services to say, I can't supply, this is outside of my control, this virus, and as a result, I can't supply this service. The client, the passenger, may still have to pay cancellation fees. That will depend on what the terms and conditions say. The supplier has said, I'm not supplying. The terms and conditions will then indicate what may or may not happen.
Great, thank you,
we've
Tim.
answered all the questions, Dan. Thank you.
I believe that's right. Thank you so much, Tim and Doug. This has been extremely informative, and on behalf of Baxter Media, I'd like to thank you so much for presenting for us today.
Pleasure.
Very good.
So again, everyone, there'll be a follow-up webinar next Wednesday at 1 o'clock. And I will share that the registration link for that in the same email that I send to all of you that has the recording and those 2 links that Doug mentioned. So I'll be sending that out likely by end of day today. But I would like to thank everyone that tuned in the webinar. Thank you all so much for taking time out of your day. Thank you, Tim, and thank you, Doug. Take care, everybody.
Good stuff.
Bye now. Bye now.